the withdrawal of the security detail of the Honorable Justice Lawrence Mugambi. Mr. Speaker, sir, I rise pursuant to Standing Order 52.1 to make a statement on a matter of national and general topical concern, namely the withdrawal of the security of the Honorable Justice Lawrence Mugambi, Judge of the High Court of Kenya. Mr. Speaker, sir, on 13 September 2024, Honorable Justice Lawrence Mugambi issued a ruling in a contempt of court proceedings against Mr. Gilbert Masengeli, the Acting Inspector General of Police, sentencing him to 6 months in prison. This ruling has drawn a seemingly retaliatory action from the National Police Service, which withdrew the judge's security detail over the weekend. This action by the National Police Service is a violation of the rule of law and the principle of judicial independence enshrined in our Constitution. It is not only illegal, but outrightly unconstitutional. Mr. Speaker, sir, Article 160 of the Constitution provides for the independence of the judiciary and states that the judiciary shall be subject only to the Constitution and the law and not to be controlled or directed by any person or authority. The withdrawal of security for a sitting judge in response to his discharge of judicial duty is a direct contravention of this constitutional provision and must be condemned. Judicial officers must be at liberty to make decisions based on law, free from intimidation or coercion. I strongly condemn the intimidation of Honorable Justice Lawrence Mugambi. We must all take cognizance of the appeal processes provided in our laws for any party who feels dissatisfied with a court ruling, rather than resort to revenge missions against the judiciary. Such actions, Mr. Speaker, not only seek to undermine the authority of the courts, the administration of justice, but also suggests that judicial decisions can be influenced by external factors other than the law. Mr. Speaker, sir, it is imperative that we take note of these actions by the National Police Service and their potential impact on our judicial system. As a retired judge and Senate Minority Leader, I have also suffered the wrath of holding the executive accountable that resulted in the withdrawal of my security detail. This unjust behavior of the National Police Service of withdrawing security detail without stated and justifiable reasons for the same must stop henceforth. Mr. Speaker, sir, we must respect the principle of separation of powers and uphold the rule of law. The independence of the judiciary is a fundamental tenet enshrined in our Constitution. It is essential for the protection of human rights, promotion of fairness, and upholding of democratic values. The judiciary must be allowed to operate free from external pressures and interference, ensuring that every case is heard and adjudicated based solely on its merits. Mr. Speaker, we must safeguard judicial independence and ensure that the judiciary can fulfill its role without compromise. Let us uphold the principles of justice, fairness, and the rule of law for the benefit of all Kenyans. I thank you, Mr. Speaker. Senator Justice Retired Stuart Mazayo, EGH MP, Senator for Kilifi County. Honorable Speaker, in March of 2023, at a sitting of that Committee on Energy, there was a resolution by the committee to conduct an inquiry into the high cost of electricity. Mr. Speaker, this is an issue that many of us in this House have interacted with. Honorable Speaker, this is an issue that had, at that particular moment in time, occupied many discussions around the country. When we began this process, Honorable Speaker, at the point at which this inquiry was initiated, Kenyans were buying Kenya shillings 100 at that particular moment in time would get you only 3 units of electricity, Mr. Speaker. That in fact, out of 100 shillings, 51 shillings were going to taxes and other charges and levies. Mr. Speaker, the committee did conduct a proper inquiry, including meetings with various stakeholders. I remember the then Minister for Energy, the Honorable Chirchir, stakeholders from Kenya Power, from Ketraco, stakeholders from the independent power producers, and others appeared before the committee. And Mr. Speaker, there is a report of the committee that was there's a report of the committee that was prepared in September of 2023. I don't recall the exact date when it was tabled in this House, but Mr. Speaker, it is a matter of record in this House that in fact that report has been tabled before this House. Honorable Speaker, if you allow me to go through some of the observations and recommendations of the committee, and I do this because those observations and recommendations out of that inquiry are the ones that informed the proposed amendments to the Energy Act in order to seal some of the gaps that we found as a committee. Honorable Speaker, at the on page 7 of the report where it has the chairpersons forward, and allowed me just to read. Honorable Speaker, one of the things that the committee noted is that there is a general opaqueness in the disclosure of the beneficial owners of power producing companies, with the majority of them listing companies, foreign companies, as shareholders. Honorable Speaker, this amendment bill is not complicated and it's not long. Mr. Speaker, there are only 3 proposals in this particular amendment bill, and as I have read to you the recommendations and observations of the Committee on Energy, they actually all flow from those recommendations and observations of the committee. If you look at clause 2, Honorable Speaker, of the amendment bill, I have proposed that an amendment be inserted in the Energy Act immediately after section 134. So this will be the new section 134A that requires a generating entity to enter into an energy purchase agreement to sell electrical energy to a licensed entity specified in the 3rd schedule. And then we go to what that a generating entity must consider when entering into such an agreement. Honorable Speaker, we have introduced the principles of public finance enshrined under Article 201 of the Constitution into the decision to enter into an energy purchase agreement. And these principles, Honorable Speaker, are openness and accountability, public participation in financial matters, good governance to ensure that public funds are used in a prudent and responsible way, sustainability, Honorable Speaker. This is as a direct result of the feedback that we got during the sittings of the committee to inquire into why these electricity bills are as high as they are, and that Kenyans are complaining that something needs to be done. As you saw, Honorable Speaker, there was a clear manifestation of opaqueness in how people determine whether we in fact need to enter into fresh power purchase agreements. So, Honorable Speaker, we have introduced a requirement there that prior to procurement of electrical power, there has to be a feasibility study that is conducted to identify whether there is enough demand for electricity purchase which cannot be met by the existing production. Honorable Speaker, we were told, if you look at your power bill, there is something called a capacity charge. That capacity charge is charged on every consumer of electricity for all the capacity that has been contracted by Kenya Power to supply power. And that capacity means, Honorable Speaker, every time you issue a license to a power producer, for as long as that capacity to supply is there, we are paying for it whether they are actually dispatched or electricity is actually bought from their generating units or not. So, Honorable Speaker, the committee felt, and this is what informed my amendment, that before you give any other person a contract on purchase of power so that they are setting up any new plants, a feasibility study must be conducted to tell Kenyans that in fact the existing capacity cannot meet the requirements at the particular moment. Honorable Speaker, this morning the team from Talo, Kenya, appeared before the Senate Committee of Energy to discuss the field development plan for the Lokichar Basin. Honorable Speaker, from the evidence that was given by the management of Talo themselves, there is a recognition across the world that now people are moving away from fossil fuel energy, and that in fact we are struggling. The reason why the field development plan and the exploration in Lokichar Basin has delayed, Honorable Speaker, is that funding and money and credit for the development of oil fields have dried up because of the increasing awareness on the need for us to cut down on fossil fuels, and many people are now moving towards investment in green technology and green energy. So they are struggling. The management of Talo themselves told us today the money has simply dried up. There are very few investors who are now willing to put money into oil exploration. Because if you look at places such as the EU, Honorable Speaker, and other places, there has even been a moratorium that has been put that beyond 2030, vehicles that operate using diesel or oil-based fuel, Honorable Speaker, will be phased out, and therefore there is a move towards greener sources of energy. So, Honorable Speaker, we want even Kenya Power to give priority to generating entities that generate through renewable technology. And we gave the example of Lake Turkana wind power. We have Kipeto as well, and even the solar generators should be given priority as opposed to those who generate using heavy fuel oil, which is very expensive. The last amendment, Honorable Speaker, the second or third one, Honorable Speaker, on the disclosures, the committee noted that many of the IPPs that have, Mr. Speaker, can I get some